Good morning, everyone. My name is Robert Carnwath. I'm chairing this session. Welcome to the Landmark Chambers Planning High Court Challenges Part 3 webinar. And we're pleased to see so many joining us for this session. And we hope you'll find it all useful and informative. The materials from the first two parts of the webinar series are in fact available on the resources tab on the Landmark website. Now, we have three colleagues today. We have James Maurici KC talking about challenging PIN's mode of determination and procedural decisions. We have Jacqueline Lean talking about injunctions in planning high court challenges. And we have Ben Fulbrook talking about practice and procedure update. Unfortunately, Matthew Henderson, who was to have been with us, has had a family emergency and so cannot join us. He had prepared slides on NPPF case law, and they will be available afterwards, but I'm sorry that he's not able to be here with us on the webinar, which means that we'll end rather earlier than expected, around midday. Now, before we start, I should have mentioned that James Maurici is not able to be with us in person, but he has recorded his presentation, so we'll be starting with that in a moment. Now, a few housekeeping points. Your microphones are automatically muted, so you will not need to adjust your local settings. We welcome questions throughout the session. Please submit them via text in the Q&A section on your screen. If you want to remain anonymous when asking your question, please make sure you tick the Send Anonymously button. And we'll endeavour to answer as many questions as we can towards the end of the presentations, but they will, and possibly some of them will be able to answer afterwards. I should say that the webinar is being recorded, and you will receive a link to the presentation and the recording after the event concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. So I think that's all from me, and we start off with James's presentation. James, I think, needs no introduction. He's a very distinguished and experienced KC specializing in particularly planning and other environmental issues. So this is his recording. Thank you.
Right. The purpose of my talk is to explore two things. One is High Court challenges to mode of determination decisions by the Planning Inspectorate. That's to say, decisions made under Section 319A of the 1990 Act as to whether your appeal will proceed by way of inquiry, hearing, or written reps. And then secondly, also to other challenges to other procedural decisions by PINs and or inspectors in the course of pursuing a planning appeal. The issue that most often arises is where an appellant seeks an inquiry, but the Planning Inspectorate determine the case should instead proceed by way of a hearing. And clearly, the appellant has to, in a statement of case lodging the appeal, set out as full a case as possible for why they want an inquiry, and they must obviously address the criteria that PINs publish on mode of determination. The criteria, of course, suggest that an inquiry would ordinarily be appropriate if there's a clearly explained need for the evidence to be tested through formal questioning by an advocate. The issues are complex, e.g., it said large amounts of highly technical data are likely to be provided in evidence. Or thirdly, the appeal has generated substantial local interest to warrant an inquiry, as opposed to dealing with the case by a hearing. Interestingly, the criteria are clear that simply because there's a need to make legal submissions wouldn't of its own be a reason why appeal should proceed by way of inquiry. Now, given the financial constraints that local planning authorities operate under, they will often argue that an appeal should not be by way of an inquiry, but by way of a hearing. There does also seem to me and others, I think, to be a bit of a drive at pins at present to push more cases into hearings, and that includes some cases which, in my view, really should be proceeding by way of an inquiry. I mean, there are, of course, obviously resource savings for pins in doing this, and not to be too cynical, it doubtless helps them with their monthly reporting of how long appeals take to determine, although of course, as we all know, it actually takes longer to get a hearing date than an inquiry date. But that said, obviously hearings are much less intensive and use up less of PIN's resources over a period of time, allowing inspectors to determine more cases. So why is it that appellants, and it is most often appellants, want an inquiry rather than a hearing? I think obviously there are three things. First, there's a perception denied by PINs, as I understand it, that for an inquiry there's a greater likelihood you'll get a more experienced inspector. Secondly, I think cross-examination is obviously an invaluable tool, both in making one's own case and exposing the flaws in the other side's case. And then thirdly, the belief, which I strongly also believe, that the quality and hence the robustness from legal challenge is generally higher for decisions that are made following an inquiry. So the PIN's procedural guide makes clear that in making their decision, they will consider the views of the main parties, as well as their published criteria, and that where their choice differs from that of the local planning authority and the appellant, they will set out reasons for their choice. And the appellant can ask, or the authority can ask, for the choice to be reviewed by a senior officer. And then it's also said they keep the procedure under review, so they can change from inquiry to hearing or vice versa as the process moves on. So if you've asked for an inquiry and PINs determine it should be a hearing, first of all, you should be given reasons why that's been decided. And secondly, what is clear is that you are, and if you're considering a legal challenge, which is what I'm coming on to, you really must ask for the decision to be reviewed first by a senior officer. If the appellant is not content with the decision made by PINs on mode of determination and on any other consequential procedural decisions, i.e. As to whether to allow you sufficient time to add to your case if you've been moved from a requested inquiry to a hearing, then the remedies open to you are to seek a review and persuade PINs' more senior officer to change its decision, or failing that, to seek to challenge the decision in the High Court. Now, in my experience, getting PINs to change its decision on mode of determination once it's made is really very difficult. I've never seen it happen. So if the appellant is very, very dissatisfied, then legal challenge might be the only possible remedy. So in terms of reasons, it is important to note the guide gives a very clear commitment to give reasons for the decision on the mode of determination where that differs from what's been requested. And that, I think, quite clearly would give rise to a legitimate expectation that there be reasons. And if reasons were not given, that itself would provide a potential ground for judicial review. See, by analogy, the Save Britain's Heritage case that dealt with call-ins at the time when there was a policy that there would be reasons given. Now, where reasons are given, and they most often are given in some form where the decision's made to differ from the parties on mode of determination, these are often what one might call crisp, and they follow the lines of something along the lines of, this appeal should follow the hearing procedure because the likely issues are suitable for a roundtable discussion format. Now, that is not terribly informative, but I think we'd all agree a legal challenge based on the reasons being inadequate in this regard would be rather difficult. So that's probably all I need to say about reasons. I think the next question is, what's the form of challenge? If you're going to challenge this mode of determination decision, how do you go about it? And when do you go about it? So the only safe advice on the form of legal challenge is that you should bring a judicial review proceeding within 6 weeks of PIN's final decision on the mode of determination. So where you've requested a review from a senior officer, which you clearly should have done before you go to judicial review, it will be within 6 weeks from that final decision by the more senior officer. Now, what it is not safe to do in this situation is to not challenge the section 319A decision by way of judicial review, but to get on with your planning appeal, and then only if the appeal eventually goes against you, to seek to challenge that final decision on the appeal under, assuming this is a section 78 appeal, section 288, on the basis of unlawfulness, usually that's unfairness, in the decision on the mode of determination. Now, that's not a safe course, because there is authority to the effect that a challenge to a mode of determination decision under section 319A is not usually challengeable under 288 at the end of the process, but instead only by a judicial review brought within 6 weeks of the decision. Now, this case law is really a lot messier than it should be. This should be straightforward. When do you challenge and how do you challenge? It's not as straightforward as it should be, so I need to do a quick review of the cases. So there are some cases where a challenge to a section 319A decision has been entertained, albeit dismissed on the merits, in the context of a section 288 challenge or 289 appeal to the ultimate decision made on the planning appeal, whether it's under section 78 or 174. So RISA and the Secretary of State is an example of that. But it does seem on the balance of the case law that the better view, quite clearly, is that this is generally not allowed. So in Bluebell Cemetery, Miss Justice Holgate reviewed a number of the authorities. The judge began by looking at the authorities that had suggested that these decisions, 319A decisions, had to be brought by way of judicial review and could not be brought at the 288 stage. The judge then referred to the well-known cooperative retail case, and that was concerned with an application to challenge a decision by the Secretary of State refusing to adjourn the date fixed for a public inquiry. And the Court of Appeal held that what is now section 2843B of the Town and Country Planning Act 1990 only applies to decisions which dispose of the appeal. That's to say, a decision on the final outcome of the appeal. So it's only the final outcome of an appeal that must be challenged under section 288 or 289. It is not the case that you have to use those procedures for decisions which are not decisions that dispose of the appeal, i.e. an adjournment decision, which does not dispose of the appeal, is not required to be challenged under 288 and 289, but to be challenged by way of judicial review. So Justice Holgate said that on the facts in that case, the challenge to the section 319A decision should have been made by judicial review, not as it was via section 288 after the appeal had been determined. And the judge said there are sound practical reasons which in my judgment support this legal analysis. Planning appeals involve several parties. In some cases, they may indeed involve many participants with many different interests, each party potentially incurring substantial costs. It can readily be understood why the legislature has created a process of statutory review under section 288, which applies to the final determination of an appeal, leaving public law challenges to earlier decisions, where properly arguable, to be dealt with soon after the matter has arisen, so that any justifiable complaint can be addressed at that time before yet further substantial costs are incurred, potentially by several parties. However, I accept that some breaches of relevant requirements, for example, breaches of the duty to act fairly, causing substantial prejudice, will have a continuing effect which taints the final decision or outcome. Drawing a dividing line between the two must await further argument in an appropriate case. So what I take from that is generally if you're going to challenge a mode of determination decision, you really should proceed by doing that through judicial review within 6 weeks of the final decision on mode of determination. But Mr. Justice Holgate seems to have held open that there may be exceptional cases where complaints related to the mode of determination can be brought via later Section 288 proceedings, where they lead to issues of ongoing fairness in the process. Now, there is a case which I mentioned where the court entertained a mode of determination challenge under Section 288, wasn't cited in Bluebell. It doesn't seem to me that RISA is one of those exceptional cases that was contemplated by Mr. Justice Holgate. Rather, it just appears that the Secretary of State failed, for whatever reason, to actually raise the issue when the Section 288 proceedings were brought, that it really should have been brought by a judicial review at an earlier stage. So what about the outcome of mode of determination challenges? We've spent a lot of time talking about how you do it, and it's more complex than it should be. The reality is that challenging a Section 319A decision on mode of determination, whether by judicial review or exceptionally by way of Section 288 or 289, is always going to be difficult. And there's a very simple reason for that. On these kind of matters, as mode of determination, as on all other procedural decisions, a court is going to accord a wide margin of appreciation to the decision maker, be it PINS or an inspector. So looking at the cases and the outcomes, as I said, RISA was the case where a mode of determination challenge was allowed to be entertained on a Section 288, apparently without objection from the Secretary of State, but it failed on its merits. The court rejected the complaint. There's then the Westerly case. In that case, there was a challenge to the final decision, again, via Section 288, on the basis of fairness, but closely tied to the mode of determination. The judge questioned whether it was appropriate for those mode of determination issues to be raised in Section 288 proceedings. But the judge didn't actually dismiss the challenge on that particular basis. He went on to consider the merits of the challenge on mode of determination, despite questioning whether it should have been brought in that way. So the claimant argued that the inspector should have decided that the nature and complexity of the evidence required the appeal to proceed by way of a hearing or a public inquiry, not by written reps. And this was a case where there had been substantial local opposition to the scheme, which had been rejected by the council, and it was contended that in following the written reps procedure, inadequate consideration had been given to a key issue, it was said, the choice of alternative sites. Now, the court determined there had not been a failure to have regard to the criteria on mode of determination, and the judge held the conclusion on the mode was not unreasonable, irrational, or otherwise unfair. And the judge said it was appropriate for the inspector to exercise what was called his professional judgment in deciding how the appeal should proceed. And importantly, that although one of the criteria for a case going by way of inquiry is the level of local opposition, simply because there was a lot of local opposition did not make it mandatory that there be a public inquiry or indeed a hearing. So the claim was ultimately rejected. There's then Chochar and the Secretary of State. So this was an enforcement case. The claimant appealed under Section 289 against a dismissal by an inspector of their enforcement appeal. The authority had issued a notice on the basis that he breached planning control by using a detached structure within a property owned as a separate residential unit, which was not incidental to the enjoyment of the main dwelling. When he appealed, the claimant said he wanted the matter to be dealt with by written reps. PINS wrote to the claimant about the merits and disadvantages of that process, mode of determination. The council then submitted, under the written reps procedure, their written statement, which said the claimant had confirmed that the use of the separate unit had ceased. Now, this was not the case. The claimant didn't accept that was the case, but he didn't raise the error. Now, the inspector ended up rejecting the claimant's appeal, and the claimant in the 289 appeal said the inspector had acted unlawfully in determining the appeal without holding an oral hearing. Interestingly, again, there doesn't seem to have been any issue raised by the Secretary of State that really this was a challenge that should have been brought at an earlier stage by way of judicial review. What happened? Well, the judge rejected the claim. He said the claimant had, of course, elected to start with for written reps. It'd been open to him to request an oral hearing, but he hadn't, even after he saw the counsel statement of case and that there was a factual dispute. So the claimant was held to have made an informed decision, particularly because in that case he'd had a letter of advice. It was noted that it was the Planning Act 2008 that removed the automatic right to an oral hearing in planning appeals. The judge held to the extent the claimant had a general right to an oral hearing under Article 6, which query whether anyone actually does, that he'd unequivocally waived it. And fairness did not require a hearing, regardless of the party's wishes. There was no requirement under the criteria, the judge said, for there to be an oral hearing. It was also noted that PIN's initiative was to seek to determine more appeals by way of written reps, which I'm sure was true then and probably still is. And the inspector had to have regard to the criteria, but he was an expert tribunal acting in a quasi-judicial manner, and so therefore had a broad discretion over the manner in which the appeal were to be conducted. Then Norfolk. So this is one where there was a 6-day inquiry into conjoined appeals. The planning inspector had allowed the appeals and granted permission, but the council challenged that under 288, and the decision was quashed by consent. So PINS initially decided that the appeals would then be redetermined by a process that involved a further public inquiry in front of a different inspector. But the new inspector appointed to examine the file concluded that the issues could be dealt with by written reps instead. The planning authority interested parties who were local objectors disagreed, and PINS determined that because there had been no significant change in circumstance since the original decision was made, and there were no complex issues involved and no need to test or clarify the evidence, a public inquiry was unnecessary. It concluded that the issues raised could be dealt with through the written reps procedure. That was challenged by the council by way of judicial review this time, so the generally correct method, contending that they'd not properly interpreted or applied the criteria for determining the decision. And again, the claim failed. The judge noted the question was whether PIN's decision and its reasons showed that their guide and criteria had been misinterpreted or not applied properly. It was said the new inspector was well able to assess the evidence and take their own view as to how it should be redetermined. The judgment about how complex the issues were and the need for testing of evidence, etc., was primarily a question for the inspector's judgment and unchallengeable in the court proceedings. And again, emphasising that just because there was widespread interest and lots of local objection doesn't itself amount to a reason why an inquiry has to be held. Moreover, it was said the inspector gave adequate reasons for that decision. So what do we get to? I've actually not been able to find any judgments where there's been a successful challenge to a Section 319A decision, whether through 288 or 289 or judicial review, which may be telling in itself about what your chances are in relation to this. That said, there may well be cases that have been consented on in relation to this. However, there are some interesting cases that I think are worth noting in this context. They're not direct Section 319A challenges, but they're probably worth mentioning. There are a number of cases where judges, mostly deputy judges, members of the planning bar, have made statements to the effect that the cases before them should really have been determined by an inquiry or at least a hearing rather than the process that was used. So just to note a couple of those, Ricketts, which is quite an old case now, Graham Eyre, QC sitting as a deputy High Court judge. He referred to the fact that the written reps procedure had been used and said, obviously has its benefits in times and in terms of time and cost, but then said this, on the other hand, there's no doubt that an inquiry did give to the parties an opportunity to test the material rather more directly, effectively and efficiently, that seemed to be an inherent characteristic of an appeal by way of inquiry as against an appeal by way of written reps. The general problem was that there were many cases coming by way of appeal to this court, which on analysis demonstrated that material was not sufficiently tried or tested, or indeed that the material was not tried or tested at all. So a caution from the court that there are cases which are really not appropriate for written reps, and which they, needs to be clear, do need to be tried and tested. Then Richmond upon Thames, there was an affordable housing issue, and the court had held the inspector had failed to interpret the policy properly or calculate the contribution properly. And the judge added that, having quashed the decision, this was His Honour Judge Gilbert, that they had sympathy for the inspector. This was a classic case where cross-examination would have exposed the flaws in the argument, but that is not what happens at an informal hearing. This was one of those types of planning dispute where the inspector should have insisted on an inquiry, where there would have been formal cross-examination, which would have tested the two rival methods of calculation. So again, they're showing that when you have complex issues that require testing, really the courts are pointing in the same direction as the criteria that should go to an inquiry. Similarly, Pratt development proposed was a change of use of an agricultural building. Charles George QC, sitting as Deputy High Court Judge, said the appellant had initially requested a hearing, but this was turned down, and said there was no challenge to that under 319A. Again, that seems to support the view you need to go by way of judicial review. And then he said, in these circumstances, the task of the inspector was not easy, absent the assistance which might have been afforded to him by cross-examination at a public inquiry or by the interplay with the parties at a hearing. So again, recognising that there are cases that are not appropriate for the written reps procedure. And then I think finally, in terms of these cases, Mahajan, enforcement appeal determined using written reps, challenged under 289 at the end of the appeal. The judge clearly thought that this should have gone to an inquiry. The enforcement notice was directed at a ground floor extension to the rear of the claimant's dwelling. The inspector concluded that the development had not been substantially completed 4 years previously, and that permission should be refused. In the 289 appeal, it was said the reasons were inadequate that the inspector gave. The claimant had initially asked for a hearing rather than an inquiry, and a date was fixed, but then the claimant fell ill and agreed to written reps. But really, the court was absolutely clear that this was a case that probably should have gone by a different method. So Vince determined the appeal by written reps. The inspector said something strange, which was because it was written reps, limited weight could be given to the evidence that was given on the Ground D appeal. And the court decided the inspector was clearly wrong to do that, because limited weight would apply to all of the evidence because it was untested by cross-examination, and that he'd wrongly downgraded the evidence of the appellant. And the judge was quite clear that really the matter should have been explored through a hearing, or more appropriately, an inquiry. And then I suppose I should also mention Waltham Forest. The issue here was whether a decision arrived at following written reps was adequate or not. The challenge was rejected, but the notes in the JPL noted that having agreed to written reps, the parties had little cause for complaint if their evidence was less appreciated than it might have been at a hearing or inquiry. However, where a point occurred to an inspector or was not raised by a party, he or she may need to consider whether to invite further written reps or propose a change of procedure to address it. And the JPL concluded by commenting that the case illustrated why parties should consider carefully their mode of appeal. So that deals with mode of determination. Just on other procedural challenges, just to deal with those very briefly, the following procedural decisions are all things which you really should be challenging by way of judicial review. So refusal to adjourn an inquiry, decision to adjourn an inquiry, a letter from the Secretary of State indicating they'd be disposed to grant conditional planning permission once a satisfactory agreement had been concluded between the appellant and the Highway Authority. And then there's a more complex issue, which I'll touch on, about how you go about challenging a refusal to entertain an appeal. So just briefly on the other procedural decisions, just a handful of cases to mention. Carla, at an inquiry post-exchange of proofs on the first day of the inquiry, the appellant sought to lodge a report on the suitability of the site for recreational use and lead a witness to speak on it. The reporter, this is a Scottish case, refused to allow this, and the appeal proceeded and was refused. Carla challenged, relying on the refusal to admit the document and the witness. And the ministers argued that a decision on a procedural character, such as refusal of an adjournment or refusal to admit a witness or document, should have been the subject of judicial review. But the court, so the court distinguished co-op, holding that a procedural decision may be founded on or in a challenge against the final decision if it's a reason of a kind to justify holding that the inquiry was flawed in such a way as to vitiate the final decision. Now, the case failed on its merits, but there the Scottish court seemed content to entertain that challenge to a procedural decision, to refuse to allow a witness to be called and to put in a report, to be entertained through a challenge to the final decision. And then just very briefly, three things. One is interesting case in the information law context about using the EIR to try and get PIN's advice on mode of determination. That's the Adams case. Paddon is just an example I want to give you of why, just because the reported cases don't show any successful challenges to 319A, doesn't mean a judicial review of a mode of determination decision can't have some effect. So here, an objector challenged the mode of determination decision, and the PINs offered to reconsider on the basis that the JR was withdrawn, which happened, but then they decided on the same mode of determination. The case went off in a hearing. The objector was actually successful in resisting the scheme, but the matter is now back in the High Court in Section 288 proceedings by the developer. And then finally, Link Park Heathrow, the inspector there, following a 2-day hearing, made a decision that the court found to be flawed on many grounds, and leading counsel before the High Court had appeared at the hearing and was able to assist the court on what had gone so horribly wrong at the hearing and the ways in which the inspector had gone astray. But again, it's one of those cases where you look at it, it looks clear that really it should have been proceeded on the basis of an inquiry. So that's all for now. Thank you very much, and sorry I couldn't be there in person and had to pre-record this, but I am at an inquiry that's overrun. No challenge to that decision. Thank you very much.
Good morning. I'm going to move on to look at planning injunctions in High Court challenges and some of the cases that have been floating around over the last 12 months to do with planning injunctions more generally. So just by way of a quick overview, I'm dividing this up into sort of 3 sections. Firstly is focusing on some specific cases and some points that have come out about 187B of the 1990 Act specifically. Moving on to look more generally at the issue of interim injunctions and judicial reviews, and some points that have been floating around in planning or environmental cases that might be of relevance more generally in the planning context. And then just finally, very quickly at the end, just to pull together a couple of other cases that may be of interest if there's a injunction going forward that's to do with specific things, or a couple of points that may be of relevance when considering whether to go down that route or such like. So firstly, on 187B, this is where there's been a bit of a flurry of activity, I think it's fair to say, over the last 12 months. I'm picking up in particular on 3 High Court cases: Braintree, DC, and Secretary of State for the Home Department, Ipswich, BC, and Fairview Hotels, and also Waverley, BC, and Gray and others, to talk about in terms of substantive decisions or points that have come out of the High Court. Fenland and Great Yarmouth are 2 more in the series of Ipswich, so useful on their facts, and Epping, Forest, DC, and Halama, which I'll come on to towards the end of this session, is actually about the High Court trying to give some general guidance to county courts, but it's a useful review and overview of considerations under 187B, particularly where you're looking at in contexts which aren't perhaps the gypsy and traveller context where we've seen so much of case law over the last few years. So moving firstly to Braintree DC and the Secretary of State for the Home Department. Now, this was the Court of Appeal consideration of a case that was before Mr. Justice Waxman, where the council was seeking an injunction under 187B to restrain the government's proposed development of the former RAF airfield to use it for accommodation for asylum seekers. Now, there were a few arguments floating around before Mr. Justice Waxman. The key one was jurisdiction. That the court simply didn't have jurisdiction to grant such an injunction under 187B because this was Crown development on Crown land or development on Crown land. So it was caught by the preclusions in section 296A of the Town and Country Planning Act 1990. There was also separately an argument about whether or not what was happening was development at all, or which could be constrained, or breach of planning control, which could be constrained, or whether or not it was permitted development under the emergency powers given to the Crown under the General Permitted Development Order. But it was the jurisdiction point that really was a cause for concern for the Court of Appeal. Now, Mr. Justice Waxman struck out the claim for an injunction as the claimant had not received consent from, quote, the appropriate authority under the 1990 Act. Now, to put that in context, there's some specific provisions in about section 292 onwards to deal with the applicability of the TCPA to Crown land. And what it said in section 296A subsection 2 is that a local planning authority must not take any step for the purposes of enforcement relating to Crown land unless it has the consent of the appropriate authority. Now, in that case, the appropriate authority was the MOD, and funnily enough, the MOD hadn't given its consent to the council taking enforcement action against the Secretary of State for the Home Department. And we get some more guidance on what's meant by a step taken for the purpose of enforcement in section 296A subsection 5, which is that a step taken for the purposes of enforcement includes A, entering land, B, bringing proceedings, and C, the making of an application. Now, Mr. Justice Waxman, having reviewed a bit of the historical documentation, was pretty comfortable, I think it's fair to say, that an application for an injunction under 187B did fall within the prohibition in section 187B. And it's pretty clear that the purpose of an injunction is to enforce against an actual or an apprehended breach of planning control, and bringing proceedings for was clearly a step taken for the purpose of enforcement action. He did give permission to go up to the Court of Appeal, and essentially on a point of general importance, the Court of Appeal, in perhaps even shorter terms, had no hesitation in upholding his decision, taking the view that an application for an injunction under section 187B was undoubtedly a step taken for the purpose of enforcement, for the purposes of section 296A2. Now, to some degree, that this case might be seen as restating what perhaps quite a few commentators have seen as the orthodox position, which was you can't do many things against the Crown, which under enforcement powers that are ordinarily available to a local planning authority. You can serve an enforcement notice, but you couldn't prosecute because it's not a criminal offence. So firstly, you can't get an injunction to try and restrain it, or to try and require the Crown to comply with an enforcement notice. But there is quite an interesting traversing of some of the historical provisions and the changes that led to that in the High Court decision, and some useful consideration by the Court of Appeal on the competing arguments both ways that were put forward, particularly to do with whether there was a difference between an actual and apprehended breach, and such like. Now, Mr. Justice Waxman, well, I think the High Court decision is particularly interesting, although it's not really perhaps directly on point for injunctions per se, also took the view that that he felt that the development that was sought to be restrained would seem to fall within the permitted development rights granted to the Crown under Class Q in Part 19 of Schedule 2 to the GDPO. Now, he was at pains to stress that he didn't really need to go on and consider that because of what he found on jurisdiction, but given he'd heard arguments, he traversed it anyway. And came down in favour of the Crown in that case, looking at the breadth of the term emergency and such like. That was also raised to the Court of Appeal. The Court of Appeal declined to get into the point, taking the view essentially of saying, well, we know it's been looked at, and no doubt a future court would look carefully at that, and by convention would expect to follow what Mr. Justice Waxman said unless it's wrong. But we don't think it's helpful for us to plough in at this point in time, because we don't want to bind the hands of any future court that might be looking at this, either in terms of departing from Mr. Justice Waxman or in terms of following Mr. Justice Waxman, if we were to say something unhelpful now. So actually the point was picked up, interestingly, a case I'm coming on to a bit later on, the West Lindsay case. But I think it's fair to say that's sort of a perhaps a watch this space. I think an interesting one that just generally is matter of planning law is something to be bashed out, no doubt in cases that will be coming down the pipeline in due course. Now, moving back to the injunction context, and we're still in the context of the Secretary of State for the Home Department essentially suddenly being put on the spot in some respects, although the actions of the Secretary of State for the Home Department coming into the planning realm. And this was this case I'm referring to next, Ipswich Borough Council and Fairview Hotels Ipswich Limited. Well, I think it's fair to say the first really substantive consideration by Mr. Justice Holgate of injunctions to restrain the use of hotels as accommodation for asylum seekers. Now, in the Ipswich case, there were two claims that were being looked at where ex parte injunctions had been granted, restraining uses of hotels in Ipswich and in the East Riding of Yorkshire for such accommodation. And the alleged breach of planning control in that case was a change of use from hotel to hostel. Now, it's an interesting case, partly because, as is characteristic of Mr. Justice Holgate's judgments, you often get a very useful purveying or going backwards and forwards through the broader legal principles that apply in this context. And there's quite a detailed consideration of the case law as to what is a hotel and what is a hostel. But there were 3 points I wanted to pick up in particular that are useful, I think, when considering injunctions in the 187B context more generally. Now, the first is that when we're looking at this issue of necessary and expedient, the LPA has got to be satisfied not only that it's necessary and expedient to take enforcement action per se, but it's necessary and expedient to do so by seeking an injunction. And as part of that, Mr. Justice Holgate obviously picked up on the point that it's not necessary for a local planning authority to take or show why it hasn't gone down the route of other enforcement action, or why you don't have to do other things before an injunction. But that you can perhaps expect a local planning authority to explain why it's gone down the injunction route if it hasn't taken other action previously, and that comes out relatively clearly from a discussion on a point he didn't have to decide about whether or not there was a requirement to have an officer's report that detailed all of this, and saying, well, it would certainly at the least be helpful to the court to have a report that set out why officers consider or are recommending to the decision maker that, you know, the injunction route should be the one that is pursued. Now, the second point to pick up is irreparable harm. Now, again, there was a bit about looking at quia timit injunctions generally in terms of restraining apprehended wrongs, and whether or not this point about there having to be irreparable harm, which was a general principle of quia timit injunctions, as Mr. Justice Holgate accepted, should be applied here. And he was quite clear at paragraph 97 that he wasn't persuaded the principle should be applied to section 187B as a threshold test. That would not accord with the breadth of the language used by Parliament. Instead, the issue of whether the apprehended breach of planning control would cause irreparable harm unless restrained is one of the factors to be considered by the court in the overall balance. And the third point, just to pull out, and to some degree this probably goes to the serious issue to be tried, maybe rather than the balance of convenience per se, is about the use classes order, and reiterating that the purpose of the use classes order is to provide that development in the form of a change of use from one use within a class to another use within the same class isn't deemed to be development. it doesn't extrapolate out, meaning that if you change a use from something within one use class to another use outside that class, that necessarily means there has been a material change of use. And obviously that was particularly of importance here, where hostels, which had previously been in class C3 with hotels, had been taken out and were a sui generis use. But it was essentially reiterating that just because a hotel might be in C3 and a hostel sui generis, that does not mean without more that there has been a material change of use, and as such material change of use that without planning permission would be a breach of planning control. Now, in terms of the substantive consideration in that case, the court considered that firstly there was a triable issue as to whether there was a breach of planning control, and taking as a starting point, which was a point that was reiterated a couple of points in the judgment, that the distinction between hotel and hostel use in a case like the one at present was fine. And the factors in that case included the fact that there were specific provisions around occupancy and shared occupancy being between people who knew each other, that 3 meals a day would be provided in the hotel restaurant, there'd be no cooking facilities available to residents, that there was a bit of a traversing of the particular facts and how the building was proposed to be used under the contracts that probably went into that. Secondly, that damages would not be inadequate, or the judge even said would it even be available as a remedy. But then on to balance of convenience, the court felt that it was clearly a case where the factors in favour of discharging the injunctions which have been granted outweighed those in favour of continuing it. And a couple of points that I pulled out in particular. One was there was an allegation that there had been a flagrant breach of planning control, and the court didn't think that was the case here, and pointed out that the arguments about hostels, hotel were there were some respectable arguments whether there wasn't a breach of planning control and what they were doing was lawful. Secondly, also pulling out the fact that the context that there was a statutory duty on the Secretary of State to provide accommodation for destitute asylum seekers. That was something the court clearly considered to be material. And thirdly, also that the court found on the facts, or took the view on the facts, that the councils hadn't shown that the use gave rise to substantial planning harm. And just in that context, it's helpful to have regard perhaps to what's said at paragraph 112 of the judgment, which is that the claimants accepted in each case the proposed use would not cause any environmental damage or any harm to the amenity of the neighbouring uses or any harm to the character and appearance of the area. The buildings would not be altered and there'd be no issues related to traffic generation. So again, that sets some of the context for this concept of substantial planning harm. And in terms of the importance of upholding the integrity of the planning system and the enforcement system, the court noted and accepted an argument from Mr. Brown KC, Paul Brown KC, that essentially here there's no suggestion the integrity of the planning system would be undermined by the normal enforcement regime, which would allow an alleged breach of planning control to continue while the merits of an appeal were under consideration unless a stop notice was served. And so the question was what was the strength of the public interest in an immediate injunction before the alleged breach even begins. So again, that was the arguments often deployed is, well, it's important to uphold the integrity of the planning system. And it's clear there's quite a nuanced argument being put forward there that gave the court pause for thought as to you can't just accept that as a harm that goes against balance of convenience. You do need to look quite specifically at the specific harms that are being alleged and the particular facts of the case. Now, this case is also quite interesting because the court, again, was just a whole case, perhaps unsurprisingly, had something to say on some of the procedural aspects of the matter. And I think it's fair to say there was some critical, implicitly critical commentary on the steps which the councils had or hadn't taken to obtain a fuller picture of exactly how it was proposed that these buildings were going to be used or how the use for asylum seekers were going to be managed prior to commencing action, and also on the justification or otherwise for pursuing ex parte applications. The question really being there as to why did these need to be without notice? Why were they so urgent? Why? Not really seeing why that there couldn't have been some notice given to the defendants in that case, the intention to seek interim relief. So again, some useful reading at 56, 62 and 66 on the procedural aspects of the matter. Now, two cases in a similar vein or dealing with similar issues, the use of hotels for accommodation for asylum seekers. with results that went in opposite directions. Firstly, the Fenland District Council case, which is at the top of the screen there. Now, that was an application for an injunction restraining the use of a particular hotel and any other hotel in the area from being used to accommodate asylum seekers. Now, in terms of this judgment, this was a with notice application because Mr. Justice J had refused a without notice application, or felt it wasn't appropriate to be dealt with as a without notice application for any application that was issued the day before the main claim was issued. And on the facts of this case, the application was refused by Mr. Justice Holgate broadly for similar reasons to Ipswich, but there's a nuance in that case, and that part of what was argued in terms of the harm was risk to the asylum seekers themselves being accommodated there, not from the premises, but from, I think, what was referred to as the ability of the town to support that. And there were some issues around trafficking and some operations or investigations to be going on, support for unaccompanied children, things like that. But Mr. Justice Holgate was not convinced by that on the evidence. Also, in that case, he was not overly happy about the fact that the injunction was sought to restrain the use of any hotel in the area. Didn't feel the evidence really went to that and would not have made that one in any event rather than just to the specific hotel. So again, perhaps a word of caution. It's a theme that's generally kicking around in the injunction context at the moment. I think we've got a Supreme Court decision coming out on Wednesday in the protest trespass injunction context more generally about perhaps looking to be overly broad in your reach when you're applying for these sort of injunctions. And the second case, which went the other way on the facts, is the Great Yarmouth Borough Council and Al Abdeen. And that was an application for an injunction restraining the use of a particular hotel and of any hotel within an area that was protected by a particular policy of the local plan. I think it was the seafront protection policy. And on the very specific circumstance of that case, the court was satisfied that, again, Mr. Justice Holgate was satisfied that the circumstances in favour of continuing the injunction outweighed those in favour of discharging it. And I think the particular factors that came through in that case were the fact there was an extant enforcement notice from 2006 for the particular hotel in question, which had said, although the breach alleged was a change of use from hotel to HMO, the reasons given were to do with a change of use to a hostel, and the steps required to remedy it were to do with stopping use as a hostel. So there was a sense of, well, hang on, there's already been something here that's been in the background on this one. And also the policy which protected particular areas wasn't, it didn't cover the whole of the Great Yarmouth area. It was quite specific, and the court didn't see any evidence put forward as to why other hotels outside of that area wouldn't have been appropriate for the same use. I.e., why does it need to be within an area that was protected by policies that included the council resisting the loss of tourism uses to non-tourism uses, and specifically saying that use for things like HMOs and hostels would not be appropriate. So again, one thing that really very clearly comes through all the cases that have happened this year is that the fact-sensitive nature of the investigation, and those two quite closely illustrate that. Now, another one just to pick up on the 187B context is back to perhaps the more conventional sort of theme, sort of subject matter that we see under 187B quite a lot, which is an injunction to restrain change of use of land use for stationing of caravans for human occupation and associated operational development that might go along with that. So this is Waverley Borough Council against Gray and others, 2023. Now, this case illustrates the importance of a local planning authority keeping circumstances under review and making sure that it's directing its mind at various stages to whether it still continue to proceed with the claim for injunctive relief, or to proceed with it in what terms. Because here, when the council initially sought injunctive relief, the application proceeded on the basis that the land was unoccupied. It's about restraining something where there seemed to be some operational stuff going on for that purpose. And the court said that was a reasonable position for the council taken at that point. Now, after interim injunctions were made and there were some applications back and forth re-extending, the defendants moved off the site, but some of them moved back on due to changes in personal circumstances. And without going into detail of it, being mindful of the time, the court found in that case that there were significant factors mitigating against the grant of the final injunction on the facts of the case. This was very much to do with the personal circumstances of some of the defendants in particular. and also where the courts couldn't see that the council had engaged properly with the issues of the best interest of children who were on the site with the family that had moved back on due to this change in circumstances. And the evidence there was about when they'd moved off that they'd sort of been bouncing around a bit and had no choice really other than to come back. And this is the key point to pick up on, that they found there was the court found there was scant evidence to suggest that the claimant had meaningfully reviewed the original decision at key points when the identity of and the needs of individual occupants had become known. What the court said at 113 was that as each of the matters became apparent, it was incumbent on the claimant to investigate matters and to reassess the balance of factors in light of emerging information. The proportionality of the decision should have been revisited when the claimant became aware of these matters. There is scant evidence that suggests the claimant meaningfully reviewed the original decision at key points when the identity and needs of individual occupants became known. The impression gained is of an initial decision being taken to pursue injunctive relief and the claimant pursuing it to a final injunction without pausing to reevaluate the appropriateness of the use of coercive measures on becoming aware as to the personal circumstances of the individuals they were concerned with. And the court stressed there the court's original jurisdiction on 187B and set out why the court didn't feel, based on the information it had seen, that it could go down the route of granting final relief. Also bearing in mind that local authority chose to seek injunctive relief as opposed to, for example, serving an enforcement notice. There was no evidence that they'd given consideration to other enforcement powers. Just finally in this section, Epping Forest District Council and Halama. So probably not a case that's necessarily of burning and scintillating importance in and of itself on the facts. It was a claim for an injunction to restrain a situation where there'd been planning permission granted or PD for a bit of an extension, and then the claimant had built something bigger, and then there'd been an enforcement notice and it had been varied to remedy the steps, and then there'd been an application for planning permission and certain different things have been allowed. But ultimately what was left on the ground was something that was bigger than what was permitted whenever you piece together the jigsaw of the different authorizations and permissions. And why this one I've pulled out as particular interest is the judge in that case actively tried to pull together general guidance for county court judges who might be dealing with these 187B injunctions in the context of things like construction in a domestic dwelling context, as opposed to the gypsy traveller context, which is the one where there's been the much greater wealth of commentary. So the judge in that case pulled out 5 stages or 5 questions that a court in that situation would particularly need to look at. Is there an actual or apprehended breach of planning control? That's what it says on the tin, but quite a useful traversing of some of the points. Was the LPA's decision to apply for an injunction unlawful on public law grounds, stressing there a distinction between decisions to or not grant planning permission as distinct from the decision to apply for the injunction itself? So bringing in matters like procedural fairness or the public sector equality duty, things like that. Thirdly, what other enforcement steps, if any, have the LPA taken? Again, stressing that there wasn't an obligation on them to do it, but that is a relevant consideration as to what have they considered? Has it worked? Has it not worked? If they've not done anything else, why not? Why have they gone straight to injunction? Is an injunction necessarily expedient? Again, a useful traversing of some of the case law on that. And then finally, is it necessary and expedient and commensurate with the actual or apprehended breach to grant the injunction following the guidance of the reporter? And if so, on what terms? So again, this is the point that comes across from the Ipswich case as well, which is granting it commensurate to the planning harms that are complained of that underlie this. So even if you think it's necessarily expedient to do something, is the injunction that's sought commensurate to the harms that are said to arise from the breach of planning control? And the reference there to Porter is the classic South Bucks and Porter decision of the House of Lords in 2003. Now, moving on briefly, interim injunctions in judicial review claims more generally. One case to talk about, West Lindsey District Council, again, another foray of the Secretary of State for the Home Department into planning law, but also some general observations about interim injunctions in JR or planning statutory review claims more generally. What I should say is this is a short session. I'm going to pull out a few key points, but James Maurici and I have recently had an article published in JPL, which is looking in more detail at interim relief in planning and environmental, judicial and statutory reviews. It's 2023, 11 JPL 1383, and it was published about a month ago. And we look there at things like the test for injunctions under the Senior Courts Act versus the test under 187B, the impact of the Aarhus Convention, the differences between statutory challenges and judicial reviews, the role of stays and interim declarations. So a bit more detail could be found on these matters in that article. So in terms of the case, I particularly wanted to talk about West Lindsey District Council and Secretary of State for the Home Department. I said this was a JR challenging the decision of the Secretary of State to deploy RAF Scrampton for the purposes of housing asylum seekers. And it was a JR to the policy decision. It's the I am going to use RAF bases for these purposes. So it's not a 187B, it's a straight JR on grounds of things like irrationality, ultra vires, failure to have regard to material considerations, that sort of thing. And the claimants sought an order quashing the decision, but also an injunction to restrain the movement of materials, equipments, people onto site until the claim had been determined, i.e. don't let them start using it till you decide if it's lawful court. And also a challenge to the acquisition of the site by the Secretary of State from the MOD. Court didn't really go into that one too much. Now, the court traversed the merits of the case a little bit. This is just one feature that tends to come out in, I find, in these interim injunction cases in the JR stat review context. On the one hand, the court will often say, well, it's not for us to get into the merits. But on the other hand, you'll often get some traversing because the strength of the claim is relevant to either tribal issue or balance of convenience. And it depends which case you read as to which of those two limbs or both that it goes to. But you do kind of get this slightly odd, well, we're not really here to go into the merits because it's just, is it a tribal issue? But on the other hand, we're going to do a little bit of the traversing of the merits too, because that's relevant to our decision on discretion. The court said, the court was clearly a little bit sceptical about the merits of some of the grounds being advanced, particularly when it was to do with irrationality, which obviously at stretch was a high threshold. Material considerations were one of those that haven't been looked at. But said it wouldn't go so far as to say there was no serious issue to be tried. But it was pretty clear that on the balance of convenience, it thought the arguments were in the Secretary of State's favour. And again, you see similar themes cropping up in this case to the ones that were discussed in Ipswich. So the fact there was a duty on the Secretary of State to address demand for accommodation for asylum seekers, what the planning harms really were said to be, those sort of things. Now, there is quite an interesting point that's raised in that case, which has sort of been floated, but I think left over the determination at a later stage. I think this one, I've got a sense of feeling this one in some way, shape or form has gone upstairs. But there's quite an interesting point from the injunction side that was raised as to whether or not Section 296 of the Town and Country Planning Act 1990, which was at issue in the Braintree case, has any relevance to granting a interim injunction in a JR, which isn't brought under 187B of the Town and Country Planning Act. Now, the Secretary of State advanced a few arguments about, yes, it did apply, or in any event, it was a discretionary, even if not a jurisdictional bar. And again, the court said, well, I don't think I absolutely need to decide this. It's very interesting. I don't really need to get into it. But I do see some attraction in the argument that that might be might be relevant in terms of discretion or discretionary bar, because it would seem odd that you can't have an injunction under 187B against the Crown unless you get the consent of the appropriate authority. But you can go off and get an interim injunction under CPR Part 25 if you don't mention 187B. So possibly one that might be popping its head up again, or one to look out for. Quite an interesting point on the injunction side, it seems to me. And now just some general points on interim relief more generally. 3 things to pull out. Expedition where interim relief sought. One thing that's pretty clear generally from the case law is where the courts are granting interim relief, you can pretty much expect an order for expedition to follow. Doncaster MBC and Doncaster Sheffield Airport Limited, not a planning case per se, but a challenge by Doncaster Metropolitan Borough Council to the decision of the appeal group to close Doncaster Sheffield Airport. Very interesting case for many reasons, not least that whole is a local authority JRing what looks like a private operator. But one of the points Mr. Justice Fordham stressed in that case was if he'd been minded to grant permission, he would have been minded to grant an interim relief. And he would have then ordered expedition given what's going on. And it's a theme you see also as well floating around in some of the cases that I've mentioned a bit earlier. And another theme that's coming out is maybe an inclination on the part of parties to ask for the courts to suggest expedition instead of an interim relief. So again, not in the planning context, but the environmental context. Richards, the Environment Agency, that was a challenge to the EA's regulation of a landfill site in Staffordshire. Due to emissions of hydrogen sulfide. And there was initially a claim for interim relief that came on for an early hearing before Mr. Justice Fordham. But it was sort of agreed at that hearing that actually the matter could all be dealt with by an expedited timetable rather than granting the application for interim relief. So something to think about. Secondly, considering permission and interim relief together, this is something that seems to be happening more and more. It happened in Doncaster. So the Doncaster case considered both the interim relief and application for permission to apply for judicial review together, and also in Packham and Secretary of State for Transport. So again, going back a bit into time, but this was an application for interim relief for an injunction to restrain some felling of trees in some ancient woodlands, pending a wider decision to the government's decision to proceed with HS2 following the Oakerview review. And what's quite interesting in that case is essentially what Mr. Justice Holgate and Lord Justice Coulson, who was the divisional court, said, which is, well, it's sort of really difficult in this case to divorce permission from, you know, serious cases to be tried, isn't it? So even though it was only a hearing in theory for the interim relief application, it ended up being for permission as well. So something to be aware of as a practice point going forward. And also just something to think about, we pick up on this in a bit more detail in the JPL article, is Doncaster took pretty much a whole day. Packham took pretty much 2/3 of the day or a whole morning on the arguments. There's a suggestion in the Mass Energy case from the Court of Appeal back in 1994 that, you know, in some cases, should you just be looking at arguability where the courts had the benefit of a huge amount of argument, maybe had quite a lot of detailed information before it, and query, is there really any more that would be coming out as a substantive hearing? Should you just be applying arguability? So something just to be aware of as a potentially floating around point in case somebody raises it or you might want to raise it yourselves. And thirdly, perhaps it goes without saying, the importance of promptness. And that does come up in the Lindsay case. The court said, well, we don't think there's an issue of promptness. We're not going to refuse this on grounds of delay. Doncaster NBC, there was an issue around delay. Delay was taken front and centre by the defendants, both on the interim relief application and on the application for permission to apply for JR. The court said wouldn't have refused permission on grounds of delay, even though it had been 5.5 weeks since the decision had been known. But it would have affected the scope and extent of the interim relief sought. It would have been very tightly constrained interim relief that the court would have granted, bearing in mind things that had happened and the time that had moved on. So some general points just to be aware of in the interim relief context, which seem to me equally applicable to interim relief generally in the planning context, as they do to the specific instances in which they were raised there, albeit those were in a sort of slightly more quasi-planning environmental context than the sort of pure planning challenges that we might more ordinarily be dealing with. And then just finally to flag, really rather to talk about a few other cases that might be worth having a look at. I started, I think, by saying that, or saying earlier on, a lot of these considerations are hugely fact sensitive, and Maidstone and Brazil and South Downs National Park in particular illustrate that. So Maidstone, Brazil was a successful claim for a final injunction to restrain use of residential occupation, useful to compare and contrast with Waverley in terms of maybe what the councils had or hadn't evidenced in the two different cases that led to a different result. And similarly, the South Downs National Park in Nash was an application for an interim injunction, and again helps to look at on balance of convenience in terms of the risks of going too broad with what you're asking for. And the other two I've just mentioned is Wilden and Forest of Dean. It's a committal case, reactification of suspended committal order, bit of a useful review of what happens where there's been a committal order suspended and then the individual still doesn't do what they need to. And Dyer and Webb, completely left field decision. It's actually in sort of a civil claim for between some neighbouring landowners. But one of the things sought there was an injunction in private law terms to restrain harassment, including putting in spurious objections to planning applications. That bit wasn't successful, but the first time I've come across objecting to planning applications as being relied on as sort of a form of harassment that somebody wants to restrain by injunction. So with that, without further ado, I pass on then to Ben.
Hello, everybody. Thanks very much. Thank you very much, Jacqueline. I'm going to talk to you about practice and procedure and give you an update, which will include a tiny bit on Aarhus costs as well. So hopefully the slides will start clicking along in a second. One moment. There we go. In terms of a summary, I'm sort of going to follow the broad shape of the different types of claims that you will get in the High Court in planning claims, save for injunction claims that Jacqueline has spoken about. So talk a bit about the Administrative Court Guide, which applies mostly to judicial review claims, but obviously has clear relevance to claims under Section 288 and claims under Section 289, and before touching briefly on Aarhus. So the new Administrative Court Judicial Review Guide was published just last month, and there are a few changes that it's worth picking up on briefly, just to draw to your attention. The first is that, and you may have picked this up in some cases recently, but there has been a growing assertion of the principle of open justice. You can see paragraph 7.12.1 of the Admin Court Guide is new, and it's just an assertion there. As you say, the guiding principle is the principle of open justice, that the administration of justice takes place in public. Now, that's not of limited relevance to planning claims in the High Court, because it'd be very rare indeed that anyone would be seeking anonymity, for example, in those proceedings, or be seeking to withhold documentation to any large extent. But it also has fed in, I think, to what I've put there in the second bullet, which is an increased judicial frustration at public authorities applying excessive redactions to documents. And that includes redactions as to the names of officials who've been involved in decision making. And this can sometimes arise in planning cases where the sort of default position of public authorities is to protect the names of its officers from judicial proceedings by redacting them, particularly by redacting them as not being relevant to the decision making, because the argument goes, it doesn't really matter who made the decision. What you're challenging is the decision itself. Those sorts of arguments have been quite strongly criticised recently by a few judges in the administrative court. Among them is Mr. Justice Swift, who made a clear comment to this effect in the case of FMA in the Secretary of State for the Home Department, which was a case in which I actually acted for the Secretary of State. I'll just read you the final paragraph of his judgment where he picks up on this issue. So Mr. Justice Swift said, one further matter needs mention. The Home Secretary's initial open disclosure included documents redacted to remove the names of civil servants who had written them, including redaction of the names of the officials who had prepared relevant consideration minutes. The redactions were said to be on the ground of relevance. Documents were served in that form without the permission of the court. These redactions should not have been made. It is one thing for a document that genuinely deals with different matters, some relevant to litigation, others irrelevant, to be redacted on grounds of relevance. It is another matter entirely for a document that is relevant to be edited to remove information that goes to explain the document's provenance and context. One example, which has recently become common, is when emails are redacted to remove details such as the name of the sender, names of recipients, or the names of the persons copied into the message. Such information should not be redacted on grounds of relevance. Such redactions, at the least, make the significance of documents more difficult to understand, and in some cases, they may obscure the significance of a document almost completely. If a party wishes to redact information from disclosable documents, an application to the court should be made, and the application should explain the reason for the proposed redaction and, when necessary, set out supporting evidence. So it's worth being aware, if you're acting particularly for defendant public authorities and you have, for whatever reason, correspondence or documents written by officers to disclose, for example, in detailed grounds of defence or summary grounds of defence, that you should not generally, as a general rule, be redacting names from those documents. And if you are, you should be seeking the court's permission to do so. The general rule is that the names of officials should be public. They, as Mr. Justice Swift said, they help the legibility of the documents, but they can also be relevant in ways that perhaps might not be anticipated by the defendant themselves in terms of giving context to the decision. So that is definitely something to have an eye on. Then on the duty of candour, no real changes as you might expect to the duty of candour, but there was a judgment, you see in the second bullet point, HM and the Secretary of State for the Home Department, where the Divisional Court essentially talked about the sort of quite well-known Treasury solicitor guidance on the duty of candour, which is now some vintage. I think it's something like 2010, but adopted that as effectively correctly setting out the law. And that guidance includes the statement that the duty of candour applies at all stages of the judicial review, including when responding to the pre-action letter. Obviously, that guidance has been in place for a long time and has generally been followed by public authorities, particularly obviously central government. But it's not an uncontroversial principle, but it's worth being aware of. But certainly that judgment in HM is quite frequently relied upon now by claimants who sometimes accompany pre-action letters with quite significant requests for disclosure of relevant documents, which obviously can be extremely burdensome at the pre-action stage. there's sort of two responses to that. The first is to note the slightly differing judgment of the Divisional Court in the British Gas Trading Limited case, which said that it's usually the grant of permission which is the trigger for the duty of candour and cooperation with the court to arise. That is an interesting case. I think it's perhaps safer to go with the TSOL guidance, and particularly the idea that the duty of candour would at least arise in summary grounds of defence before the grant of permission. But what I think is also important to bear in mind is that the duty of candour does not include a duty, and necessarily a duty to provide or disclose documents. And so it is a duty to just ensure that everything that you write down in a pre-action response is a fair representation of the facts as you have them in front of you, and the documents as you have them in front of you. Doesn't automatically entitle a party to disclosure of specific documents. So that is a point to be aware of. Then there are some guidance given on factual disputes. These are very rare in High Court planning cases, but they're a sort of fairly major change to the guidance, which just accompanies the judgment of Mr. Justice Chamberlain in the case of F, Surrey County Council, and you can see there 11.2.3 of the Admin Court Guide sets out the relevant principles, which obviously states as follows. If the court is invited to resolve a dispute of primary fact, the court should consider carefully whether any pleaded ground of challenge really requires resolution of the dispute. In most cases, the answer will be that the resolution of the dispute was for the decision maker, not for the court. The court's supervisory function does not require it to step into the shoes of the decision maker, and therefore does not require it to resolve the issue for itself. And that is almost always going to be the case in planning judicial review, statutory review claims, but there might be some circumstances where it's not, and procedural fairness might be one of those examples, where there's a dispute about who did or did not say certain things. Where the resolution of a dispute of primary fact is necessary, the court usually proceeds on written evidence. The court will generally do so if no application to cross-examine has been made before the start of the substantive hearing, and that obviously reflects the fact that cross-examination in judicial review claims is rare, but not unheard of, including in planning cases. There's no absolute rule that the court must accept in full every part of the statement of a witness who has not been cross-examined, whether the statement is adduced for the claimant or the defendant. The court can reject evidence in a witness statement if it cannot be correct. That might be so if it's contradicted by undisputed objective evidence that cannot sensibly be explained away. Courts have also rejected evidence given in witness statements as, on balance, inconsistent with other written evidence. In some cases, the court may be unable to resolve a conflict of written evidence on a question of primary fact. In that situation, the court will proceed on the basis that the fact has not been proved. This will be to the disadvantage of whichever party must prove the fact. These are important principles that's worth being aware of, particularly if you are a claimant or defendant seeking to dispute a factual matter that's arisen in the context of a High Court planning claim. It's also worth noting, I think, often factual disputes or disputes on evidence arise where defendants seek to put in after the fact evidence, effectively giving some further detail about decisions that they have made or reasons that they might have had for decisions. Often those disputes can go to weight as well as whether something's correct or not. And so it may be that you can make your submissions on that basis, that the evidence after the fact should either not be admissible or should be given limited weight. And there are various authorities on that point. Then a few other matters, slightly random, but perhaps of some relevance to planning court hearings. The first, if you have dealings in Wales, that is now the case that documents in Welsh can be put before the court. And at any hearing in Wales, parties have the right to address the court in Welsh. I suspect it's very unlikely to arise, but it could arise. And that section of the Admin Court deals with that. Is now the case that requests for remote attendance at hearings must be made by application. So you must put a formal application in if you wish to attend the hearing remotely. It's not something that can be informally arranged with the court office or with the judge. And third, it's really a reminder or reiteration that where you're making an application to the court or where you're including evidence with, for example, your summary grounds, your acknowledgement of the service, they should be accompanied by indexed and paginated bundles for the court's convenience. Right, now a few points that have arisen this year, in the last 12 months, in claims under Section 288 of the Town and Country Planning Act. So the first is Telford and Wrecking, and it's I think it's a broadly uncontroversial principle, but it's a matter that often catches out claimants in Section 288 claims, and that is the requirement that claims need both to be filed and served within 6 weeks of the grounds for bringing the claim arising, which is 6 weeks of the decision notice, effectively. Everyone generally knows that claims need to be filed within 6 weeks, and that's the same in judicial review claims. But a key difference between judicial review claims and claims under statute and claims under Section 288 in particular is that you also must serve within that 6 weeks time. You do not have what you have in judicial review claims, which is an additional 7 days to serve after the claim has gone in. And so, unfortunately, the claimant made this mistake. In this case, the claim was filed within 6 weeks, but was not issued by the court or served until after that 6 week period had elapsed. The claimant argued that Practice Direction 54D, which is the practice direction applying to planning court claims, should be read alongside CPR Rule 54.7, which is the rule dealing with service in judicial review claims, i.e. you get 7 days after the claim has been issued to serve the claim. Now, Mr. Justice Eyre disagreed. He said that Practice Direction 54D was a complete code, and therefore service had to be effected within that 6 week period. And if it had not been, then an application for an extension of time would have to be considered. And that's an extension of time for service. And on the facts, the application for the extension of time was refused. So a really important lesson is if you are bringing a Section 288 claim, you need to get it ready before the last day for filing, because you obviously have to file it, have it issued, and then serve it within that 6 week period. So it's really, really important that you sort of look to that last date, plan forwards, and make sure that you leave enough steps leave enough time to take all of those steps before the time period elapses. A similarly unfortunate series of events arose in the case of Home, Farmland and Secretary of State. This was effectively a strikeout application that was made on behalf of the Secretary of State in response to a claim under Section 288. It effectively deals with the mechanism for filing. When is a claim actually filed for the purposes of the deadline under Section 288, and also deals slightly with service as well. So what happened here is that the deadline for filing and serving the claim was the 3rd of November. On the 2nd of November, the claimant attempted unsuccessfully to file the claim on the CE file system, which is obviously, as many of you know, the electronic system, filing system that courts are currently pioneering. At that point, CE file had not actually been introduced into the admin court, so he was unable to do that. He then emailed the admin court office for advice and was told that he could file the claim either by email or by posting it to the administrative court office Dropbox. The claimant did not want to file the claim electronically. So on the 3rd of November, at about midday, he paid a courier to attend the Royal Courts of Justice and deposit the claim form and bundle in the ACO Dropbox. This is important, and a significant feature of this case is that I think it's the first case to really consider this issue after the administrative court office counters were closed. So the only way of physically filing a claim form in the ACO now is to put it into the Dropbox. You cannot hand it over at a counter. So the claim form was put into the Dropbox at 15:45, but as you can see there, the Dropbox is only emptied twice a day, and the last collection had been at 2:30. So what it transpired was that the form would not be collected until the next day. On that same day, the claimant emailed the unsealed claim form to the Government Legal Department. Now, on the next day, the Administrative Court Office, having received the claim form, came back to the claimant with a few queries and issues relating to the fee and the names of the parties, asked the claimant to amend the claim form. The claimant did so and tried to resend the amended claim to GLD, but to the wrong address this time, and it was finally sent to the correct address after some period of time had elapsed, the 25th of November. As you can see, the Secretary of State said the claim wasn't filed in time because it did not reach the Administrative Court Office. The claimant argued that obviously because since you couldn't reach the counters, claim forms are effectively deposited or filed with the ACO when they're placed in the drop box. Mrs. Justice Lang disagreed. She found in favour of the Secretary of State. And this is the principally important point for people acting in this sphere. A claim is not filed when it's left in the drop box. It's filed when it's taken from the drop box to the Administrative Court Office and approved for filing by the staff. Mrs. Justice Lang criticised the claim in that case. She said he could have notified the court office that the claim had been left in the drop box after 2:30 p.m. and needed to be filed initially on the day, and maybe that would have made a difference. They would have come and picked it up. He didn't do so, and in any event, the claim was not filed on time. So effectively, if you are looking to file a claim under Section 288, be aware leaving it on the drop box on the last day is not a safe course of action to take. And if you do have to do that, do try to make contact with the office directly. So the claim wasn't filed on time, but in addition, the claim wasn't served on time, because you might remember from the previous slide that on the 3rd of November, the claimant was only able to send by email the unsealed claim form to the Government Legal Department. That's not enough to affect service, because there was no live claim at that point, it having not been issued. And so the claimant also had to extend time or get an extension of time for service. And just on that point, Mrs. Justice Lang held, consistently with the Good Law Project case, that the rule to be applied is not the typical rules for relief from sanctions under Denton and White, but Rule 7.6 of the CPR. And that basically requires a claimant to show either that the court was responsible for serving the claim and failed to do so, or that the claimant was responsible and took all reasonable steps to serve. So there's no question of prejudice or anything like that arises if you have to show you've served all reasonable steps. And generally, if you've left it to the last minute, a court will be pretty unsympathetic to you. Claims under Section 289. Now, so the first, late last year, claim called Ibra and Dacorum Borough Council. The claimant, as you can see there, issued a judicial review of the Secretary of State's decision to dismiss his enforcement appeal, along with a judicial review of decisions made by the local planning authority. The sort of the central target of the claim was an Article 4 direction, which had been made, the claimant said, unlawfully, and which had effectively disposed of his enforcement appeals. He issued the claim as a claim for judicial review because he said there were issues of fact which the court had to consider, and that Section 289 did not allow the court to consider matters of fact, just points of law. And so he said he was right to issue the claim as a judicial review, but also it happened that he'd issued it outside of the 4-week time limit for bringing a Section 289 challenge. So he argued to the court that judicial review was appropriate, that 289 was not an adequate alternative remedy. Mr. Justice Eyre disagreed, saying that, as you can see there, only in the most exceptional cases would the court find that Section 289 was not an adequate alternative remedy. Now, there are very few actual differences between Section 289 and judicial review, but nevertheless, Mr. Justice Eyre considered that Section 289 was a specialist and dedicated route for these appeals and would be an adequate alternative remedy in almost every case, and made the point that there'll almost never be a distinction between grounds that can be brought in a JR and grounds that can be brought in a Section 289 claim, which is restricted to points of law. Therefore, I think the learning point from that really is, if you're bringing a challenge to an inspector's decision on an enforcement appeal, you should, the safest option really is, almost whatever the nature of that appeal, to bring it under Section 289 is to do so within the 4-week time limit. If it turns out that it should in fact be a judicial review, the court's likely to be more sympathetic than the other way around. And indeed, in Mr. Ibra's case, he, having been made alive to the issue, made an application to the court in the alternative for an extension of time. So if the court found that the claim should have been a 289, he should get an extension of time. Mr. Justice Eyre rejected that He said that A had persisted in a deliberate decision to proceed with a judicial review even after the point had been taken, and so the extension of time shouldn't be granted. But it's also worth noting that he found that the claim would fail on its merits in any event. Then we have Willoughby. So there you see that the appellants, it's a slightly unusual case effectively because the appellants appealed enforcement notice and a refusal to grant planning permission. So the appeals brought under section 174 and section 78, and then the appellant actually succeeded in both of those appeals before the inspector. So he got planning permission that he was seeking, but the inspector imposed 2 conditions relating to parking, to which the appellant objected. So he brought claims challenging the inspector's decision under section 288 and 289, but he included within that an unusual request for relief, in that he did not want the planning permissions quashed for obvious reasons, just wanted the 2 conditions to be struck down as being unlawful. The Secretary of State argued that the appellant's claim was not justiciable because he had succeeded. He got his planning permission and could not be said to be a person aggrieved. But in a permission decision, Karen Ridge, sitting as Deputy High Court Judge, didn't agree with that. She said that the claim was justiciable, that if the inspector had made an error of law to the detriment of the claimant, then the claimant or appellant was the person aggrieved. As to what relief the court would be prepared to grant, that was a matter for the substantive hearing. So I think we remain to see what that would be. And then I think the final case under section 289 is the case of Maurici, Secretary of State. So the appellant challenged a decision to dismiss her enforcement appeal under section 289. She got permission to appeal, but after that point, she was declared bankrupt. So she got permission to appeal from the High Court, then was declared bankrupt. And her trustee in bankruptcy disclaimed her interest in the property, which was the subject of the appeal. Now, having happened, the appellant attempted to continue the appeal in her own name, and the Secretary of State asked for it to be struck out as an abusive process. And Neil Cameron, King's Counsel, sitting as a Deputy High Court Judge, agreed with that. So the point was that upon the appellant's bankruptcy, her cause of action in the appeal had vested in the trustee in bankruptcy, and so she had effectively lost it. Now, the trustee could have assigned it back to her to allow her to pursue the appeal, but it had not done so, and therefore the appellant did not have any right to maintain her appeal. And at the point at which she knew she didn't have that right, it was an abusive process for her to do so. So I think the point there is that you can assign a cause of action, obviously, but if you don't have the cause of action anymore, it'd be an abusive process to continue. Finally, then, on Aarhus, just very briefly, not much to update on, save that I certainly had just to note that the numbers of the rules have changed. I certainly had a moment recently where I was bringing a judicial review claim and just looking up a point on the Aarhus Convention, and suddenly found the rules had disappeared, and slightly concerned for a few minutes there before I realised that they have been moved into part 46, and so the rules themselves are effectively the same, but they now just feature in part 46 as opposed to part 45 where they used to be. So that's just something to be aware of if you're bringing these types of claims. Those are all the updates I have for you, and thank you very much for listening. And I think now we move on to some Q&A. It may be me, but I think Lord Carnwath possibly is on mute.
There we are. Yes. Mute. I should be all right now. Yes.
Yes.
Thank you. Well, I think we've really come to the end of our allotted time, and there don't seem to be any specific questions there, but there's some comments in the Q&A which are quite interesting about situations in which there have been discussions about hearings and others. But I think there are no specific questions, and as we said, we're going to try and finish at 12 o'clock. I think it just remains for me to say thank you to our speakers, both present and absent, and to wish you all well. I see now there's some other questions coming in, but we can perhaps have a look at those afterwards. There's someone, yes, a link reference to the judgment about redactions. Well, we can certainly do that, I'm sure.
Yeah.
And then someone's thanking for the 3 sessions. Well, thank you. So if someone could provide the link to the judgment about redactions, is that you, Ben? I think it is, isn't it?
That's me. I can send that to Martin.
Right, okay. Well, thank you all very much. And we hope you found this very useful. And I wish you well for the rest of the day. Goodbye.
Thank you.